check that everybody can hear me. A simple thumbs up will be appropriate, so I can see on screen. Okay, I'm just seeing plenty of thumbs coming out now, that's fine. That's great. There are still, I think, 2 parties to join us, if they are this morning. That's Patrick Munro. So if Mr. Munro is there, if he can appear on screen, that would be helpful. And the other party is Mr. Fleet, and I haven't seen Mr. Fleet appear as yet. Sorry, Miss Reid?
Yes, I am Patrick Munro's unable to make it today, so I'm attending covering for him.
Okay, so you're representing Burgess Salmon for Kirkton Wind Farm Limited, yes?
Yes, that's correct.
That's great. Thank you very much for that. We'll just give it another minute to see whether our last party will join us, if that's okay, and then we will commence with the meeting. My apologies, I've just noticed there's another party not attending so far, and that's from the Community Council, Gillian Bundy. I don't know if Miss Bundy is online either. I'm not seeing any name. So we've just got 2 parties that said they would attend it and haven't joined us so far. So,
Sir, can I just advise that sometimes out at Ray Village the Wi-Fi connection is not particularly brilliant, and that may be affecting the matters. I helped the Community Council with their objection. If there's any matter that you need a comment on, I could probably cover, subject to her getting no written notice in advance. But it may just be a Wi-Fi issue, sir.
Okay, well, just as I say, I think what we'll do is I think we'll commence the meeting. And if the other parties join us, then the note of the meeting will update them on anything that has been discussed prior to them joining. I think that's what we'll do. So we'll commence the meeting. So good morning to everybody, as I've already said, and thank you for attending the meeting this morning. My name is Gordon Reid. I'm a reporter with the Scottish Government's Planning and Environmental Appeals Division. This is a pre-inquiry meeting in relation to the Strathy South Wind Farm Compulsory Purchase Order 2023, proposed by SSE Generation Limited, who are the acquiring authority. Because there are objections to this order, which have not been withdrawn, a public inquiry is to be held. I've been appointed by Scottish Ministers to consider the proposed order and the objections to it, to hold a public inquiry and to submit a report to Scottish Ministers, making findings in fact and recommending whether or not the order should be made. Just to make you all aware, the meeting is being recorded and broadcast live. Our technical staff will be watching and available. I think you've all spoken to David Spears this morning. So if there's any technical difficulties, David will kick into action and sort this out for us, I'm sure. We also plan to make this meeting available on the DPEA webcasting site so that those not participating today can also view it. So by participating, you're consenting to be filmed and to the use and storage of those images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes and for the purpose of keeping historical records and making those records available to the public. I think that's all standard stuff for those that have been involved in these processes before. So I would ask, given that we've got quite a few people sort of on screen, if you could keep yourself on mute during the proceedings this morning, unless you need to speak at any point, and please be patient with me as I bring you in at the appropriate times. Also, remember to switch your mic on before speaking, which I often forget to do, which would be helpful. Given the number of participants today, you may find it easier to use the gallery view so that you can see everybody. I would also request, if you're not the lead spokesperson, I don't think it's the case here, but if you can turn off your camera so it's just the lead spokesperson that's on there, then that means I can follow it slightly easier and see any hands that go up. If at any time you want me to slow down, or you're communicating with your team and wish that we pause, then again, please let me know by either coming in or raising a hand. Again, in the case of an emergency, if you need to leave, obviously, please do not hesitate to depart the meeting as appropriate. Can I check that everyone has a copy of the agenda for today's meeting? Yeah, I'm seeing nods all around. That's great. Thank you for that. So I think what we can do now is we can move on now to introductions. So I'd like the parties to introduce themselves. So I will start with the acquiring authority, which is SSE Generation Limited, which I may just shorthand to SSE for sake of me sort of speaking that out every time, if that's okay. Then we'll go into the statutory objectors and then the non-statutory objectors. So for SSE, would you like to introduce who's here today?
Thank you, sir. My name is Miss Ailsa Wilson. I'm a King's Counsel at the Scottish Bar, and I'm instructed by CMS, who are to my left. I don't think they're on screen.
Yeah, I think you can see them now.
Yes, we can see everybody in the room, yes.
Okay, but we have Alana Barker and Mr. Robin Hutchison, who your office will have received correspondence from.
Morning, sir.
Good morning.
Morning.
To my right, I have Mr. Paul Dinan, who's the legal manager within SSE.
Morning.
Morning.
And then to his right, we have Mr. Rod Crawford, who is the Strathy South project manager, and Mr. Ian Doherty, who is the land manager.
That's great. Thank you very much. And we will move on to the statutory objectors now. I'll just, this is no particular order, it's just the order I've written them down in. So can we start with Ms. Robertson, because I think you're representing several people here. So if you just sort of introduce yourself and just maybe indicate who you are covering.
Yes, good morning. Elaine Robertson from Young Robertson Solicitors in Thurso, representing 6 lots of landowners. Morven Holdings Limited, Andrew Chadwick, Wilma Bain, Jessie Gall, Mr. and Mrs. Charles Sutherland, and Morag Mackay.
That's great. Thank you very much for that. Now, I've just noticed that Mr. Fleet is looking to be admitted into the meeting. So I will wait till I see him on screen and then I'll just... Mr. Fleet, good morning. Can you hear me?
Yeah, I can hear you.
Can you hear me? Good morning and welcome to the meeting.
Sorry for being late. Thank you for letting us in there. Thanks for that.
That's no problem at all. We've just commenced the meeting explaining what the meeting's about, just a general background to it. And all I'm doing at the moment is allowing the parties to introduce themselves so we know who is participating this morning. So I'll come to you in a moment if that's okay. But if you can keep your cell phone mute in between times, that would be helpful just in case there's any noise. Thank you. Thank you, Ms. Robertson. And on to Gary McGovern, please. Yes, Gary.
Good morning, sir. My name is Gary McGovern. I'm a partner at Pinsent Masons LLP, and I am representing 2 of the parties, being Limekilns Extension Limited and Renewable Developments LLP.
Okay, thank you very much. You were quite quiet there, Mr. McGovern. I don't know whether you became, they'll turn the volume up slightly just so that we can all hear, but it was a wee bit quiet on my side. If that's possible, that would be great. Thank you for that. Moving on to Mr. Mitchell.
Good morning, sir. I'm Fraser Mitchell. I'm a partner in the Planning and Environment Group at Shepherd and Wedderburn. and I am representing RWE Renewables UK Onshore Wind Limited.
Okay, thank you for that. And Mr. Fleet.
Hi there, yes, I'm Martin Fleet, currently joint owner of two properties at Force, Miller's Cottage and Garnery House, and just really interested on behalf of all of those landowners in the mill at Force, just to hear more about the process that's been brought by SSE. So as a landowner, I'm concerned obviously with some neighbours of this CPO, and we hope that we could come to some agreement through mutual means with the developer. So interested to hear proceedings this morning. Thank you.
Okay, thank you for that. And moving on to Highland Council.
Hi, I'm Emma Lynn. I'm the solicitor for the Highland Council, representing Highland Council.
Okay, thank you. And for Burgess and Salmon, I think we've ordered an introduction.
Yes, hi, Lindsay Reid. I'm a senior associate in Burgess Salmon LLP's planning team, representing Kirkton Wind Farm Limited.
Okay, thank you. And Mr. Kelly, I think you're representing both a statutory objector and a non-statutory objector, so maybe you could just do them both at the same time.
Thank you, sir. That's correct. I'm representing Mr. Robert Meiklejohn and Miss Catherine Haltner, and just since you have it on the agenda later, I would confirm that the intention is to present a joint case on their behalf. Okay,
thank you for that. That's very helpful. And I don't think anybody from, well, I just took the words out of my mouth. Caithness Community Council, I think, have just arrived, so we'll just wait a second for. Good morning, Miss Bundy. Welcome to the meeting. Your microphone is on mute. If you can just unmute that.
There we are.
That's great.
Sorry.
Thank you.
Yes, apologies for joining in late. My link didn't work, so I have just been in touch with DPE and their IT people have sorted it out for me. So here I am. Thank you.
That's great. We were forewarned by Mr. Kelly that it might be an internet sort of connection problem, but you're most welcome to the meeting.
Yeah. I believe there's someone else trying to get in as well that's having the same issue, so they're working on that also.
Right. I think Mr. Fleet.
Now.
Yeah, Mr. Fleet joined us later. So according to my list now, I'm just double checking that as I speak. That's everybody here now that said they were participating. So okay. that should be fine. Would you just like to say who you're representing?
Yes, my name is Gillian Bundy and I'm the chair of Caithness West Community Council.
Okay, thank you. All that you've missed so far has just been a general introduction to the meeting. So we haven't discussed any of the arrangements so far. So we're just going through an introduction of, all this will be covered in the note of the meeting. So you'll get what we've covered so far. But that's great. Welcome, thank you. And I think that's everybody. I haven't missed anybody. I'm looking for hands going up. I don't think so. Okay, so the purpose of the meeting today is to discuss the procedural arrangements for the public inquiry and for a pre-inquiry disclosure of parties' cases. And that's all set out in the circulated agenda, which I hope, as I said, everybody has a copy of. There'll be no discussion on the merits or otherwise of the order or of parties' cases today. Importantly, matters relating to compensation are out with the remit of the inquiry, but I don't see that has been raised, particularly in any of the objections, but that's just to note. As I said, I'll be keeping a note of our discussions this morning and will circulate a note of the key decisions as soon as possible in the form of a procedure notice. That notice will set out all the procedural arrangements that we discuss and agree today. As I'm taking notes, I may ask you to slow down when you're speaking or ask you to repeat what you've said, just to make sure that I have an accurate record of what is discussed and what has been agreed. So on to item 3, just a bit of background. The order is proposed to be made under the Electricity Act 1989, and so far as relating to compulsory purchase, the Acquisition of Land Authorisation Procedure Scotland Act 1947. The relevant ministers in these acts are now the Scottish ministers, as these functions have been devolved under the Scotland Act. So references to Secretary of State in these acts should be read as Scottish ministers. There are no specific rules in place for inquiries into compulsory purchase of land under the Electricity Act. However, the Compulsory Purchase by Public Authorities Inquiry Procedure Scotland Rules 1998 apply to compulsory purchase by Scottish local authorities. It's these rules that will be applied in this case, and hopefully to provide clarity over the inquiry procedures to be followed. There's also an associated circular explaining in plain English how these rules work. That's Circular 17 of 1998 as amended. I would advise parties who are unfamiliar with the process, who are attending and intend to take part in further procedure, to take time to read the rules and circular ahead of the inquiry. The DPA case officer will be able to assist any party in assessing these documents, but I'll also provide a link to both of them in the note of the meeting that will be issued. So item 4, my remit is to hold a public inquiry into the proposed order as submitted. As part of that, I will consider all objections, representations and materials presented as part of the inquiry process. So that will include all written submissions received to date. I will then prepare a report setting out my conclusions and recommendations for consideration by Scottish ministers, and Scottish ministers will then decide whether to confirm the proposed order with or without changes, or to refuse to confirm the order. So moving on to item 5, an update on the status of negotiations with objectors. I thought it would be useful to have an update from SSE Generation Limited on the status of negotiations with objectors. My understanding, as I put this together, was that there were currently 18 statutory objectors, 3 non-statutory objectors, and 4 objections now formally withdrawn. That is a moving number, as you'll appreciate, as people progress with their voluntary agreements. An email was received by the DPA from SSE this morning, providing an update on the position with two objectors. We also received a summary table from SSE setting out the current position. Now, can I just check whether people have seen the summary table or have seen the position with the 2 objectors? I'm seeing general nods. I think they're helpful information, so there's nothing there that I think needs sort of prior sort of detailed looking at. It's just an update. I think that'll be helpful as we progress with today. So the 2 emails that came in this morning relate to objections by Mr. Chadwick and Mr. Meiklejohn, who are represented here this morning. Can I just confirm with those parties who are representing them that they've seen those letters? I think Mr. Kelly, you're representing Mr. Meiklejohn.
I haven't seen a letter this morning.
Okay, right. Okay. What we'll do is we'll make sure those letters are available, and I'll just go over what they contain just so that sort of aware of that. And for Mr. Chadwick.
Yes, hello. No, I haven't seen Mr. Chadwick's letter, though it doesn't surprise me that it's been withdrawn because he's entered into his agreement.
Okay. So what the letter covers is just confirming that SSE are now requesting the withdrawal of the plots of land in relation to those 2 objections. Obviously, you can continue to object or otherwise, that's your decision, but it's an update there. So what I'll do now is I'll allow SSE just to provide an update of their understanding of progress with negotiations and objectors. So can SSE just maybe, I don't know if everybody's got a copy of the table that was circulated. That might be helpful to go through. I don't know if SSE intended to use the table as part of this presentation this morning.
It was prepared and presented by those instructing me, including Mr. Dinan, with the intention of assisting these proceedings. And with your leave, I'll invite Mr. Dinan to provide an update, as he's been closely involved in the negotiations.
Okay, I think that would be helpful, just to find out what position we are. And what I will then do is allow the other parties just to come back if there's any sort of inaccuracies, maybe at the end rather than sort of intervening. So if we go through it, if there's something that you want to raise, please note it, and then I will come back to those individuals who wish to comment at the end. SSE?
Thank you, sir. In terms of updates to the table which was circulated, there's no substantive change to that, other than the letters you referred to Mr. Chadwick, or regarding Mr. Chadwick and Mr. Maple-John's objections. To speak more generally about negotiations, we have been in negotiations with all landowners. In some instances, I think in total 8 instances, there are agreements in place. For the other landowners, we're at heads of terms stage. So there does seem to be an intention on all sides to try and get voluntary agreements over the line and progress matters. We've also been, as you'll be aware, sir, speaking to other developers, all of whom are represented here today. And there's been very good engagement from those developers, and that's very much appreciated by SSE. I think in all instances we're making very good progress in agreeing cooperation agreements with those developers to ensure that we can all operate and carry out our deliveries side by side, as it were. So I'm very hopeful that we're not too far off putting those cooperation agreements into place. That's a very general overview to what's within the table that was circulated, but if there are any specifics that, sir, you or any of the others present want me to speak to, I'm very happy to do so.
Okay, I think that's helpful, and I think the table was helpful to pull everything together into the one place. Obviously, there's potential updates from the 2 emails this morning, which are both simply are indicating that SSE are requesting the withdrawal of those plots from confirmation in the order. So these will go up on the DPA website in due course. Are there any comments from any of the parties in terms of the current status of the objection or the current status of voluntary negotiations that's listed in the table? Right, so the table at the moment is an accurate reflection of where we are with things. That can be taken as is. That's helpful. That saves us going through each individual one in turn. Thank you all for that. In terms of the plots that have been formally withdrawn from the scope of the order, I just wanted to make sure that my understanding is correct with SSE and any other parties. So as it stands at the moment, SSE have formally withdrawn, requested that be withdrawn from the scope of the order, and that relates to plots 3A to 3E. Is that correct?
Sorry, sir, the transmission broke up just as you began running through.
Right, that's no problem. I will repeat it again. That's okay.
Okay.
What I'm looking at is the plots that SSE have formally requested to be withdrawn from the scope of the order. So this isn't the objections. This is where SSE have entered into an agreement and are now requesting that the order be removed from consideration in the order. So the first one is Renewable Energy Systems Limited, and that relates to plot 3A to 3E. So I'm just looking to make sure I've got that correct. I think you've broken it with us as well now.
Can you hear me now, sir?
I've got you now. Yes, that's fine. Thank you.
Yes, Dinan has confirmed that is correct.
Okay. The second one I've got is Highland Historic Buildings Trust, and that relates to ownership in plots 18A and 18B and interests in plots 13B and 17A.
That's correct, sir.
Okay, and then, excuse my pronunciation, I don't know if this is, but Force House Fishing Bear Trust, and that relates to plots 13A to 13C.
That's correct, sir.
And as of the 2 emails that have been received in the last day, that would be Andrew Chadwick for plots 10A and 10B, and Robert Meiklejohn for plot 7A.
That's correct.
So that's our up-to-date position in terms of the formal requests for these plots to be withdrawn.
That's correct. Yes.
Okay, that's very helpful. I just wanted to make sure that so that everybody was aware of the current position with regards to the plots that you no longer seek to be included as part of the compulsory purchase order. Is there any comments from any other parties just on any of that? Okay. I'm assuming the answer is no to this, but can I just confirm with parties on whether any of their objections that are currently in place have been withdrawn or are likely to be withdrawn? I'm seeing lots of shakes of head. That's fine. So moving on to presenting sort of future cases, looking at objectors presenting a joint case, I think there may, from my understanding, maybe 2. We'll start maybe with Ms. Robertson. Oh, sorry, we can't. Your microphone's on mute.
On it off again.
Thank you.
No, can you hear me?
Yes, can hear you loud and clear.
Yes, I've no joint cases, although the reason my microphone was on and off was probably because I was about to comment on your last point that, of course, if the when the voluntary agreements are signed up for those that are on heads of terms at the moment, which are all of my other 5 clients, Mr. Chadwick now having been withdrawn, then the objection is likely to be withdrawn if the plots are likely to be excluded from the ambit of the CPO. Does that make sense?
Perfect sense. Yes, it does indeed.
Thank you.
And you're representing all the parties depending how they go forward.
Indeed, yes.
Yes. Okay, that's fine. Mr. Kelly, I think you've already indicated this to us.
Yes, sir. My 2 clients are both presenting case in relation to the principle of the CPO, so it'll be a joint piece of evidence from me on behalf of both of them.
Okay, that's great. Thank you for that. Are any other parties? I think maybe Mr. McGovern, you're representing 2 parties, is that correct?
Yes, sir. Can I just check, is my audio better now? Can you hear me clearly?
It's much better, loud and clear, yes.
Good. I need to invest in a new headset, clearly. Yes, sir. We will be presenting a joint case on behalf of Limekiln Extension Limited and Renewable Developments LLP.
Okay, thank you for that. That's very helpful. I don't think there are any other parties unless somebody tells me differently. I'm not seeing any hands going up. Okay, so for parties intending to participate in further procedure, and for those maybe less familiar with the process, when I say participate, I mean to take part in inquiry sessions, and that may mean by asking questions or cross-examining the promoter, or in the case of a hearing, taking part in a round-table discussion, rather than just attending to observe and listen to the oral sessions, which of course any of you are entitled to do. What I would say is that you do not need to make a final decision at this stage. However, it will assist me in assessing how many days to set aside for any process if we have a guide as to how many parties are likely to take part, which I hope we'll be able to establish further in procedures. Parties who have made representations on the matters to be considered at the oral sessions can indicate that they wish to participate if they respond to the procedure notice. So there'll be opportunity to do that in due course once the procedure notice is issued. So for today's purposes, I will just assume that those present are likely, unless obviously they withdraw their objection, to take part in one or more of any further procedure sessions, which we will come on to in the following items. I hope that's all clear for everybody. What I just wanted to be clear about as well, there are some parties who have already indicated that they intend to rest on their objections, and I just want to make sure I've got this correct, because I don't think any of them are here, but I've got Jamie and Marie MacDonald, plot 23. They're maintaining their objection, but they're not continuing in any further procedure. I've got Mr. Simeonite, who is a non-statutory objector. I think he is resting again on the evidence as submitted. I'm not aware of any others who are in that position, unless somebody can update me on that. Oh, okay, we'll take that as the current position. Parties who haven't responded to the DPA correspondence to the relevant notice, I've got several here, so I'll just run through these in case somebody, I noticed that other people have joined, so just to make sure that they haven't joined us in the interim. I have Adrian and Christine Brunner, which is plots 1A and 1B, Force Limited and NCGH Property Limited, and that's plots 13B, 14A, 15A, 16A, 16B and 17A. Mark and Gillian Kerr, which are plots 17A and 13B, and Ray Farms Limited, which are plots 30A to 30F and 31A to 31B. No further respondence has been received from them by the DPA officer. I just want to check that none of those parties are here today or are wishing to participate. Okay, I'm seeing no hands or any indication that no other parties are aware of any situation with these individuals. No. Okay, that's fine. I would be grateful if all parties can keep me informed of the status of their objections. Clearly, there are various discussions going on with the Inquiry Authority at this time. So I would encourage parties to progress with seeking to resolve matters through voluntary agreements, if that is possible, and to let me know as soon as possible when that is done, as it will certainly help to reduce any sort of unnecessary inquiry time as we progress. Any questions on any of the matters so far? Okay, so I think we'll move on to now looking at the scope of the matters to be dealt with in the inquiry. I did set out a provisional list within the agenda, which I hope everybody has, and that basically listed, that was Appendix A, provisional scope of inquiry, and it indicated 10 separate issues or items in there. These are the ones that I had tried to identify, group together, pull together from the wide range of objections that I considered were relevant and fell within the scope of the inquiry. So taking into account the provisional list of issues set out in Appendix A, are there any other matters that are not within the scope? I've tried to keep the scope of these issues broad enough to allow matters to be pulled sort of within them. But are there any sort of issues that have been identified that should be considered for further procedure that couldn't be covered by any of the items I've identified so far in the part of future inquiry process? I will go on to discuss how these are best grouped for consideration and process later on, but this is really just to look at the scope of the inquiry itself. Mr. Kelly.
Can I just clarify, sir, that you envisaged the issue of the principle of the need for the compulsory purchase order being covered by issue 1 in your list of topics?
Yes, by need, yes, we're talking about the principle of the compulsory in its widest sense, as well as in maybe particular aspects of it, yes.
Thank you, sir. You'll cover it later, but I think on that basis, my clients probably could focus their whole case on issue 1.
Right, that's fine. I did try to make them broad enough so that we could get as much of a focus as possible. Any other questions? Any other issues or things that I missed out within that list? Okay, right. I'm seeing shakes of head. That's very helpful. So in terms of grouping of the issues, I've had a look at the 10 items, because what I don't think we need are 10 separate sessions, and I don't think anybody would welcome 10 separate sessions by me suggesting that. So I've looked at what potentially could be grouped together in terms of particular sessions. So what I have thought initially, and this is open obviously for discussion today, is that we could potentially group issues 1, 2, 3, 4, and 8 together into a session, because I think these are on particularly more sort of general issues and points, but rather than particular site-specific matters, say like the impact on the trees, etc., which we could group separately. So I'd be looking at maybe grouping 1, 2, 3, 4, and 8 into an inquiry session, if that's considered appropriate. Then trying to group issues 5 and 6 together, given that they are looking of impact either on existing operators or businesses. So I thought that that might be an area to group together there, and then look at separately the loss of woodland and trees, and then there's 2 other items in terms of the Crass site and the impact on the Caithness Flow World Heritage Site. So I thought they probably could sit as separate items in terms of the scope of inquiry. So on that basis of suggested approach, can I just ask for the acquiring authority's view on that?
So the logic's understandable. One general question I have in terms of contemplating how we would organise the evidence, if we take the first grouping, as that's the largest group, issues 1, 2, 3, 4, and 8, are you envisaging that these topics would all be dealt with where there's a relevant witness in one witness statement, but under maybe different headings in respect of each of the topics? Or
Yes.
would be separate witness statements for
Yes, I think that's what I was looking at in terms of feedback from yourselves in terms of how you set the evidence. Anything that minimises separate sort of statements, I think, would be helpful. Looking at that, I would be looking at to try and sort of pull it into maybe one statement. It just depends whether you've got different witnesses on the sort of subjects to be covered. But again, the feedback from yourself on whether you think that's doable and the approach, so it would be welcome, given that obviously you'll be involved in every session, whereas others may be just dipping in and out of sort of individual parts to it. So really, I'm looking just for your feedback on that today, and then obviously I'll make a decision in the note of the meeting when I issue that.
in general terms, so the view is that we can make it work proceeding that basis, and there's a logic to it. First grouping is perhaps slightly different in that there's probably going to be a mix of factual matters and also legal matters. And one question for this meeting might be whether, rather than have a witness deal with legal issues, we have exchanges of written submissions on legal matters.
Okay. I'll just dip into anybody else. Does anybody else have a comment on sort of the legal matters and using sort of written submissions for that? Mr. Mitchell, your hand was up first. I'll come to you after that, Mr. Kelly. Mr. Fraser, sorry.
No, Mr. Mitchell, you're correct. First time, so
it's when the names are on screen.
Absolutely. I blame my parents for naming me with 2 surnames. Just to add what was said on behalf of the acquiring authority there, we are one of the parties who will fall into dealing with issues 1, 2, 3, 4, and 8, albeit not all of those issues. And we had certainly envisaged having a legal witness as well as a witness which is likely to be a representative of the business to speak to factual matters. And with that in mind, I actually agree. I think it may be quite helpful to have detailed written submissions on the legal point, and that may be more beneficial both for you, sir, and the other parties, rather than trying to cross-examine on the points.
Okay, thank you for that. Mr. Kelly, I think you had your hand up as well.
Thank you, sir. Initially, yes, I agree with your grouping of the first set of topics, 1, 2, 3, 4 and 8. I agree with taking the legal aspects out and having them by further written submissions, although we would not be saying much. If you take the legal issue out, then I think your first grouping of issues lends itself to a hearing approach, where you would have a hearing statement, but the option of a number of people for each party contributing to the discussion, the roundtable discussion, and that maybe gets round the issue of multiple witnesses being cross-examined. So others obviously will have a varying view, but I certainly think when you take the legal issue out of that grouping, it lends itself very much to a hearing format. And I think you would get more information, sir, from a hearing where we discussed an agenda set by yourself based on hearing statements being lodged in advance. Thank you.
Okay, thank you for that, Mr. McGovern.
Thank you, sir. Yes, I find myself agreeing with Mr. Kelly in that when I looked at the topics and thought about how best to deal with this, I did feel that a hearing session might lend itself well to the topics and the potential mix of legal points and other matters. I'm not adverse to the legal points being addressed by way of further written submissions if you feel that would be better done in that manner, but the alternative would be a hearing session, and I would support that.
Okay, any other views on this? Because I think this is the kind of the meatiest part of the process. So I want to make sure I get comments and views from all those who are going to participate. Right, yes.
Sir, sorry, just for completeness, because I don't think I'd mentioned it. In fact, Mr. Kelly obviously came after my comments, but I agree. A hearing session, I think, on the factual matters would be helpful, and that would certainly be our preference rather than inquiry sessions. And for the reasons set out by Mr. Kelly and Mr. McGovern, I think the most could be got out of those sessions.
Okay, that's very helpful. Thank you. Ms. Reid?
Yes, I just wanted to echo that we would suggest that hearing sessions is the best way to hopefully get the most useful information and discussion in relation to these topics.
Okay, thank you for that. Any other views on that in terms of process?
So the one matter that came out from the debate there is that there is, on the part of Mr. Mitchell, the distinction drawn between factual matters and legal matters. There will also, no doubt, be some quasi-factual legal matters as well. It may be that it's difficult to come to a definitive view as to how best to structure whichever sessions we have or procedure until parties either have produced their statements of case and we can see the scope of evidence that they're predicting they're going to present in relation to these particular topics. All the witness statements, although I appreciate that would be very late in the day to be making decisions about process at that stage. But I would have thought at the least to have statements of case before coming to a definite view as to whether there's going to be a split procedure between written submissions on what are purely legal matters and a hearing in relation to either clear, separate factual matters and potentially legal issues that depend upon the facts that are underlying.
Okay, that again is very helpful. Can I just ask a question in terms of an inquiry process? You're not ruling out a hearing as an alternative to an inquiry at this stage?
No, we're not, sir.
No. Okay, that's fine. I just wanted to clear that you weren't insisting that an inquiry goes ahead. You would like to see the statements of case to establish whether that's required rather than a hearing. Is that my correct understanding?
Yes, sir, on these topics that you grouped together.
Okay, right. That will give me sort of pause for thoughts. I'll look at that. What I'll do is I'll look at that and consider it I may come back to parties to clarify matters, but I will progress on the basis of looking at that certainly as an option of that. Does anybody else sort of have any concerns if we go to statements of case first and then determine sort of process after that? It may well sort of delay matters in terms of the timescale, but I'm just looking at the principle, Mr. Kelly.
Yeah, so you just picked up the issue I was going to raise. I mean, we're due to make statements of case and or hearing statements by the 30th of July. It would be and then starting the inquiry in early September, which all the dates which suit my clients. It might be very, very tight to put in a short statement of case and then a hearing statement or an inquiry report. So it's obviously for you to consider, sir, but I think it might be better to proceed on the basis of hearing statements by 30th of July, full hearing statements on the basis that we're having a hearing. And then when you see those hearing statements on the 30th of July, if you felt there were issues that merited an inquiry session, then you could come back to parties. I think otherwise it potentially could get very tight for time and slightly confusing.
Yes. Yeah, I'm conscious that it's almost adding a separate stage of decision making sort of before that. So I'll need to consider it because that was one option that I hadn't sort of looked at as a potential option. So I'll need to think through the implications of that. But what I'm hearing from parties is a willingness to be flexible to get the process moving forward in terms of the inquiry. But as I say, I will look at that in detail. Is anybody any other comments just on this kind of initial grouping sort of session, which, as I said, I think is probably the one of the main area where objections are lying. Okay, right. I'm seeing nothing else. Looking at the other issues then, with items 5 and 6, which I said are related to particular businesses or operations. Does that suit parties to have them as a separate grouped session? I'll start with the inquiring authority.
Yes, that would be suitable, sir. And we agree with the proposed procedure for those topics.
Okay, so sorry, can I just clarify when you say procedure, they're down as an inquiry session? Is that what you refer to?
Yes, that's what I'm referring to, sir.
Okay, that's great. Sorry, it's just for my clarification. Thank you for that. Any other parties who are involved in those directly? Any views on the grouping of those together? Yes. Sorry, Mr. McGovern. Your microphone is on mute, Mr. McGovern.
Sorry, I think Mr. Mitchell had his hand up first.
Oh, my apologies.
I suspect we might be about to say the same thing.
Well, you could go second or first. I'll leave it to you.
I won't steal Mr. Mitchell's thunder. Right,
Mr. Mitchell, we'll let you go first, seeing as you're number one on your hand.
That's very kind of both you, sir, and Mr. McGovern. And I suspect I'm just going to foreshadow what Mr. McGovern says, which is certainly from my perspective and my client's perspective, we have no issue at all with the grouping of those topics together. We, I think, are likely potentially only be involved in one of those topics. But in terms of procedure, it strikes me that hearing session may be more beneficial rather than an inquiry session.
Okay, thank you for that. Mr. McGovern, has your thunder been stolen?
It has been stolen, so I won't repeat what Mr. Mitchell's just said, but I would simply agree with him.
Okay, thank you for that. Any other parties, any views on that who would be participating? Ms. Reid?
We would also agree with
Okay. Any other parties beyond that? No. I'll go back to the acquiring authority then. In terms of procedure, then, in terms of inquiry or hearing, have you any strong feeling of one or the other? You did indicate inquiry initially.
The view remains that an inquiry session would be appropriate because you're going to hear evidence from other parties on alleged impacts which it's possible that the acquiring authority will challenge.
Okay.
And the best way of challenging is through cross-examination.
So your preference remains with inquiry then? That's
yes, for those topics.
Okay, that's great. Thank you for that. If there's no other comments on that, I'll then go on to the 3 remaining items, which first one is item 7, which is to do with the loss of woodland and particularly the area around Force and the TPO. I put down sort of hearing there, but for those parties that are involved in that, what would be your views on whether a hearing or further written submissions may be suitable? Again, I'll come back to the acquiring authority first.
From my knowledge, at this stage of the process, I understand that the evidence is quite straightforward and it's unlikely there's going to be controversy. I would therefore think a hearing session would be suitable.
Okay. That's very helpful, thank you. And any other parties involved? I'll go back to the council perhaps, because there's maybe a relationship in there with the tree preservation order. Any views on item 7?
Yeah, I think we'd be happy with a hearing, and I think just to echo what everybody else was saying, I would probably go for hearing process with the other categories as well.
Okay, it's very helpful.
Thanks.
Any other parties who are involved with the force area? I'm not seeing any hands up with that. What we will obviously need to look at for that as a hearing session is who's actually going to participate in that hearing session, because at the moment it would be the acquiring authority I've got and the council, and I don't know if any of the other parties who have sort of objected on those grounds would be participating. I don't know if anybody here has any that's attending today here that would have any comment. Yes, Ms Bundy, Community Council. Oh, your microphone is on mute. There we go. I think that's it.
Yes, the loss of tree coverage around Force was one of the reasons that the Community Council objected, so we do have an interest in that.
And would you...
We'd be very happy with the hearing session. In fact, as with all of the sessions, we'd be very happy with the hearing session. The Community Council has no funding to cover professional representation for an inquiry or indeed for a hearing session. So any points that we make are generally informal, and we would be relying on the evidence from professionals for most of the sessions.
Okay. Would you be participating in the hearing itself, or likely to do that? You don't have to commit yourself today, but it's just to get an idea. In the hearing.
Sorry, there may well be 1 or 2 issues where we would wish to make some comment, but we would be relying on the professionals who are presenting objections for other parties to be very much along the same lines as we would have represented anyway.
Okay, so what we can do is working on the basis that you have an interest and you will potentially be attending, but we can confirm all this after the meeting when the note goes out. So you've not committed yourself to anything at the moment. It's just to give me an indication that that's helpful. Any of the other sort of residents or representatives around that force area? Nope. Okay, that's great. That takes us on to the 2 items, item 10, which item 9. I've really put that there for sort of clarification because I think it's not clear from the submissions. First of all, sort of exactly where this is or what status it has. So I've put that there just at the moment, looking at further written submissions, just because at the moment I don't have sufficient information. I don't know if the inquiring authority have any sort of further sort of information on that, or whether it's appropriate to deal with that just as a further written submission.
Right. Further work has been carried out by the acquiring authority in an effort to identify the site in light of it being mentioned within 3 of the objections, but that's been unsuccessful. It's not been possible to identify where the site is or the relationship to the land which the acquiring authority is seeking to gain title to. In the absence of any clarity on that matter, it seems that it could potentially be a waste of inquiry time to spend time on evidence, either through hearing session or inquiry session, if it's irrelevant to the confirmation of the CPO. And the difficulty the acquiring authority has had is it's not been possible to ascertain the site and therefore the relationship to the plots being acquired.
Okay, that's clear what your position is. If any of the objectors that are here today that raised that can give me any further clarity on the matter. Well, I'm seeing shakes of head. I don't know from the Community Council whether you've any sort of local knowledge of the matter that's been referred to.
Not directly.
Okay, that's fine. I think on that basis then, further written submissions are probably the most appropriate next stage, just with those that raised it to clarify matters. Just that SSE would that be consider that to be an appropriate in principle approach?
Yes, my clients would, sir. Thank you.
Okay, and there's no comment from anybody else on that matter at this point in time. No, I've seen shakes of head all around. Thank you for that. The last item I've got here is the impact on the proposed Caithness Flow World Heritage Site. Again, I think this was raised in Mr. Kelly's submissions. So you just go to yourself first, Mr. Kelly. Do you see that as a separate item or as assumed into another matter?
It's moving forward rapidly, sir. The investigating committee has recommended that the site be inscribed. Their recommendation will go before UNESCO, a UNESCO meeting in July. The recommendation for inscription is subject to 3 other recommendations, sub-recommendations, one of which is asking the steering committee to provide an appraisal of past and current and future wind farm decisions and how they affect the World Heritage Site. So it is a matter which has to be addressed by the steering group. And I think the appropriate way forward is, yes, further written submissions, but we would need to see a statement or some sort of update from the steering committee as to how they are dealing with the recommendations, assuming that UNESCO inscribe the site as per the recommendation. I don't know the date of the meeting, sir. I apologise. I know it's sometime in July. The UNESCO committee will meet to consider the inscription.
Okay, but that does form part of your objections to the CPO in what you've raised.
Yes, sir.
Yeah, okay, that's fine. Acquiring authority, can I ask what your position is on that?
Position of principle, sir, is that it's not made clear at all by Mr. Kelly, either in written representations or indeed today, as to how it is that the compulsory purchase order would have any separate effect from the construction of the wind farm. I mean, the compulsory purchase order is seeking land to permit oversailing and overrunning. So there's no issue of direct impact on the, sorry.
I was just about to say, I think that's obviously what's in the evidence presented, and my understanding is why I put it there is that to see what the whether we need to look at further information on the clarity of what the objection relates to in relation to that. So I'm just thinking, sorry to cut you short, I'm just thinking whether further written submission is. I don't think we're at the stage where we could go to a hearing and inquiry on that on the basis of what we've got. So I think further written submissions to clarify what the actual matters raised by Mr. Kit, and also your own further written submissions will maybe help to clarify the position on that in terms of potential impact.
So thank you for that clarification, that there is still a decision to be made as to the relevancy of the objection on that ground and the extent to which there may be relevant evidence for you to hear.
Yeah, so I think further written submissions, I think, are required on that, are both parties, because I don't think anybody else has raised that. I think it's just yourself, Mr. Kelly. Are both parties happy with further written submissions on that matter?
Yes.
Yeah. Yeah, that's right. So in principle, we've gone over the scope. We've actually gone into the next item, and it's partially discussing sort of procedure. But as it stands at the moment, just for clarity, so items 1 through to 4 plus 8, in potentially in one session, 5 and 6 another. Woodlands, the Spitfire crash site, and Keitha in separate matters, most likely to either be a hearing for one and further written submissions for another. I think that's my understanding of where we've got to, just generally with those points. I'm not seeing any hands up to contradict that. Okay. So the procedure for considering matters to be dealt with in inquiry, item 7 that we're on. So just for all those parties, I know that some will be aware of this, but there are other parties who haven't been involved in these procedures before. So there are essentially 3 options available to me. One is inquiry session, as referred to, and that's where those giving evidence are open to cross-examination. The second option is hearing sessions, where I would chair a roundtable discussion on the issues involved. And thirdly, further written submissions where parties are invited to expand or clarify their evidence on a particular issue in writing. I've already provided a bit more detail on those procedures in the relevant letter that was issued to parties to help explain the more detail of that process. An inquiry is to be held as a default right of parties under these procedures, but a hearing, as we've discussed, can be used where parties agree to that process. So just to be clear, if an inquiry is requested by one of the parties, then there's a right to have that. A hearing may be helpful, again, where individuals are not being legally represented, as has been mentioned by parties this morning. However, I would advise that parties, that it's essential that there is one inquiry session if any applications for an award of expenses to be made, or if parties are intending to do that. So that's just a point of sort of procedure. I'm not saying we have to have an inquiry session, just to be clear. So I think we've had sort of an initial discussion about further procedures and whether we consider them appropriate. So I don't know whether there's any benefit in having further discussion on hearing on inquiry for each of those. I think what we've sort of agreed generally is that for the first grouping of issues that an inquiry process would be appropriate. However, a hearing may be an option, and that would be reflected on what is set out in statements of case and what the implications of that. I'll need to think through sort of that process and the timing and whether that's appropriate. The second grouping, 5 and 6, the inquiring authority have suggested an inquiry and the others have suggested a hearing. I'll have to look at that and sort of come to a view on the appropriate basis for that. I've heard the issues raised by the acquiring authority in terms of the ability to cross-examine, so that is noted as part of that. In terms of the remaining issues, I think the loss of the woodland could be a hearing session, depending on, again, what's raised in statements of case for that. And the other 2 matters of the Spitfire Grave and the Caithness World Heritage Site would cover off with further written submissions that would be set out in the note of this meeting. Is that a fair summary of where we've got to? So I'll just go to the inquiring authority first.
Yes, thank you, sir. That is a fair summary.
Okay, thank you. Any other party, any comment on any of that? Or have I summarised accurately where we've got to? I'm just looking around and seeing nods. That's fine. I'm glad I managed to work the way through that. So just to go through proposed structure of sessions again, this is just for people who are maybe less familiar with things. From our discussions, we've got a provisional grouping of sessions and potential further procedure. So I will consider these matters and issue my position in the note of the meeting, which will be a procedure notice. I would remind parties that there's opportunity for parties with the same issues views to group together to present their evidence. So it is possible for you to come together where you're maybe not represented and do that. Again, that helps with inquiry or hearing time, where we're reducing the number of potential sort of repetition or evidence being duplicated. So that is something for parties to consider. Legal submissions. If any party is considering making any legal submissions that could affect the running of the oral sessions, then please lodge them as soon as possible and do not wait till the start of the proceedings, as delaying any such submissions is really contrary to the spirit of prior disclosure, and it is wasteful of expensive hearing time and unfair on other parties. If we have an inquiry session, then closing submissions would be made in writing after the close of the inquiry, and the timings again would be agreed at the end of the inquiry, with the objectors making their submissions first and SSE generation a few days later. So looking provisionally on item 8, which is dates for the venue, likely duration of oral process, I had provisionally indicated the week commencing the 2nd of September 2024 for the site visit, and the inquiry session generally starting on the 3rd of September. Now, I have a difficulty with that because I'm now no longer available for part of that week. So my apologies for that. But what I would be suggesting, and this is again provisional, and obviously provisional what we've discussed earlier, would be moving the dates forward to the week commencing the 9th of September. And then that would be the site visit on the 9th and the inquiry commencing on the 10th. So that's pushing it back a week in terms of the available time. I'm not expecting you to immediately react to that. I'll put that out in the note of the meeting, and if that's not suitable, then we will have to split the parties. Mr. McGovern.
Yeah, thank you, sir. That does present a difficulty from my perspective. One of the key parties instructing me and who I anticipate would attend the site visit and also give evidence is due to be out of the country between the 9th and 30th of September on a long arranged holiday that can't be moved. So those dates wouldn't suit from our perspective.
Okay, thank you for that, Alf. I think trying to get a date that suits everybody is going to always be difficult, so we'll need to review that. Any other initial sort of comments from any parties? Mr.
Yes,
Kelly? Oh, sorry. Who's going first? Mr. Kelly, you had your hand up first, so.
We don't necessarily need to ask your availability, sir, but I wonder in terms of your availability, if you'd given any thought also to the length of time that we might need for evidence, or the other possibility is would it be possible to use the week beginning the 2nd of September for evidence sessions over 2 or 3 days, and for you to undertake a site visit on another time when people or parties were available? It's just a suggestion for you to consider, sir.
Yeah, is the following week unsuitable for you, Mr. Kelly? Just to check.
It's okay for me. I need to check with my clients. I can speak for them just now.
No, I'm not. As I say, I'm not expecting people to react instantly today. So what I'll do is I'll ask people's positions for that and gather them together, because there's obviously a reasonable number of people involved in this process. Clearing authority, I think you had.
Thank you, sir. Yes, a matter that I think should be canvassed by the acquiring authority this morning is that we will be seeking a delay of a month to the start of the inquiry, because one of the individuals who would have been the main witness for the company in terms of the engineering, the justification, the pinpoints, and the alternatives, is on paternity leave until the 27th of September and is unable to return before that. It's already anticipated that he will not, in the circumstances, be, I was going to say fit, but that's open to misconstruction. He will not be giving the evidence, and we're finding a substitute to give the evidence in his place. But it's anticipated that a further month in terms of preparation would be required because somebody new is coming into the inquiry team with a fairly pivotal role. And to ensure that there's no prejudice by replacing that witness, Mr. Taylor, by the new witness, it's thought appropriate to seek a month's extension to the start, perhaps starting on the 1st of October.
Okay. Just as a rough canvas around other parties, does that have any implications for anybody else? Mr. McGovern, I think does that suit you with your problem with that week that I suggested?
We'd certainly support moving everything back. So from my perspective, we'd be inviting you to move the dates back a bit further in time. Obviously, my witness would only have just arrived back in the UK a few days before the start, and we would need at least some time to prepare and review all of the evidence that's been submitted with that particular party. So I'd be proposing, ideally, it would be moved back until the middle, to late October, to give us a few weeks to prepare.
Okay. Any other comments from any of the other parties? Mr. Fraser? Sorry, Mr. Mitchell, I apologise. You're still on mute. I need to write that down.
So it's a score draw. Just from my client's perspective, they are reasonably flexible. Their view is that they don't want the delay to last longer than is absolutely necessary. One thing I would flag is that within that, the date range that's been mentioned, I know that we will have some difficulty the week commencing the 14th of October. But that would be the only time, so far as I'm aware, as matters currently stand, just with the change in dates, I may have to take instructions, but as matters currently stand, that's the only week I think we could not do.
Okay, thank you for that. Anybody else, any comments? Mr. Kelly?
Obviously, so there's quite a range of dates being canvassed now, and I need to check for my clients. I could probably manage without any difficulty on any week until we get to the week beginning Monday, the 28th of October, when I would be out for basically 2 weeks without major diary shuffling and negotiating a holiday change. But I can probably manage right up to the week beginning Monday, the 21st of October without undue difficulty.
Okay, that's great. Thank you for that. And the council?
Thanks, sir. No, I was just going to say that I think probably the longer it's pushed back, the more likelihood there is of developers and potentially the council reaching agreement with SSE. So I don't know if that's something to bear in mind as well.
Okay, that's helpful. Before I say anything, I'll just give the chance for anybody else. I've not seen any other hands up. Okay, what I'm conscious of is obviously to deal with this in the appropriate timescale, and I think it's been mentioned not to push it back for any sort of necessary delay. I'm conscious that there's obviously issues with witnesses, and there's obviously discussions ongoing between parties. But what I don't want is it to end up just being pushed back into sort of the distance. So I think we do need to fix a date. What I will ask parties, I'll send out an email today asking parties of their sort of availability in that October. So at least I've got all the accurate. I've tried to write it all down, but I think it would be helpful just to get sort of that confirmation of the availability of parties, see whether there is a week that actually works for everybody in this case. It may not be that we could fit everybody completely, but we'll need to try and do the best that we can to do that. So I'll write out just to make sure I've got all that information as accurate as possible. I know that I'm available through October, so it's not a problem from my point of view, and the later part of September. So I think on that basis, I don't know whether we can potentially look at really the timescale for the sessions, but I think professionally, probably the most time-consuming session I think will be for the issues group 1, 2, 3, 4, and 8. I appreciate that parties probably haven't had the time to think how long it would take them to present their evidence sort of at this stage. The other matters in terms of the hearing on issues 5 and 6, I'm thinking that's likely to take a day, 2 days at the most, depending on the procedure. And for the other issues, the hearing on the trees, that may well be something that's quite a short sort of virtual sort of hearing. So that could be half a day. So I'm thinking that the main time will sit in that initial session. So we'll need to give thought of how long that will take. Again, it'll be dependent on whether it's an inquiry session or a hearing that we go for. So I'm thinking that at least that would be at least probably 2 to 3 days potentially. It might be shorter if it's a hearing. So just very quickly, and I know that this is very provisional, have parties any initial sort of thoughts on just sort of timescales for these? We'll start with acquiring authority.
So 2 to 3 days, I think probably 3 days is a more realistic expectation. It will depend upon how many objectors are intending to participate in relation to those 5 topics and how many of those 5 topics. It will also depend the extent to which their entitlement to make representations can be met through written submissions, so that in the oral sessions of the hearing, we're dealing with controversial factual matters rather than legal issues. That would affect the length as well. And certainly, as far as the acquiring authority is concerned, the preference would be to use written submissions for the legal issues and perhaps have a date for those ahead of factual evidence. So, for instance, the framework can be seen and understood by other parties if the legal submissions are exchanged and everybody's going into the hearing session properly understanding what each party's respective position is on the law.
Okay. So just, I accept there's lots of what ifs and maybes within sort of this, so it's a guesstimate. But provisionally, if it's as many people involved as there could be at this point, which may reduce over time depending on whether people are still objecting, I think provisionally sort of 3 days is a rough sort of indicator for that sort of process. Again, I'll have to have a think and reflection on it of what we said today, but I'll put that down as initial sort of starting point for that. Any other views on that? Kelly?
Obviously, sir, you'll want to err on the side of caution, but I think if you take item issue 3 out, the legal issue, and have separate written submissions on issue 3, then bearing in mind that not everybody will be contributing to every item that's left, I think, and if you have a hearing, which I think with multiple issues and multiple parties is better, I think 2 days would be more than adequate for that. But sir, that's on the assumption that you agree to take item 3 or issue 3 out as a separate further written submission item.
Okay, thank you for that. Any other comments? Okay, right. So I will reflect and review on what we've discussed because I has thrown it slightly more sort of complicated than a smooth run through. So I will look at the best way to do that, and then I'll issue that as part of the note of the meeting. Any other comments on that before we move on? Okay, that's great. So again, this is looking ahead provisionally. So if we are to have an in-person inquiry, or whether the hearings to be in person, which again we will have to determine, we would need somewhere conveniently located in the area for participants, with parking, disabled access, reasonable acoustics, good value for money, etc. I think provisionally, just as part of that, I'll have the case officer to check the availability of venues, but any suggestions from parties or any venues that have been used before, if they were to be forwarded to the case officer at the DPA, that would be sort of helpful. So if you've been involved in previous inquiry sessions or anything there, and there's a venue, then please forward that on to me, or if you know of a convenient one. It's particularly convenient for obviously the people who live in the area and have got to come along to the meeting. Okay, so as part of the yes.
Might be helpful if I just raise this now, because we have given some thought as to what might be a good venue, and one suggestion that's been made is a location within Thurso, and I thought it might be helpful just to sound out what the reaction would be to a location in Thurso. It's the Way In, which those instructed me have attended before for an inquiry. It's in Thurso. They considered it was a good venue, it has good parking, and there were no IT issues, which was perhaps more important for the WebEx connection.
Parties familiar with that, or are happy to I'm seeing a nod from the Community Council. In terms of location for local people to get to, is that suitable and appropriate?
Yes, it's as easy as any, so yes, I would support that.
Okay, that's great, that's very helpful. Could someone forward the details of that on to Morag Smith, the case officer? That would be very helpful from the acquiring authority.
Yes, we'll do that, sir.
That's great. Thank you very much for that. That's much appreciated. Item 9, accompanied site visit. I would intend to visit the land affected by the order, and I would prefer to do that prior to the start of the inquiry, so I'm familiar with it. I will now have to rearrange the date, but my intention was to try and do it the day before the inquiry starts, particularly if it's in person, so that I'm up there seeing the sites and then moving into the inquiry or hearing session, depending on what that would be. So I'd be looking to do that the day before the inquiry session, if that works in terms of timing. So I would ask the acquiring authority if they, given that it's a linear route with lots of different parts to it that they are familiar with, if they would make the appropriate arrangements for the site visits, including an itinerary for that. What I would say, if other parties are coming along, that they would minimise the number of representatives, because I'm conscious that this is on roads and perhaps on bends, and it's maybe not the easiest of sites to visit in large groupings. That doesn't exclude anybody from it, but it's just so that we can manage that situation. So I think what I would be looking for, depending on the date that we end agreeing with, that the draft itinerary would be submitted, say, 2 weeks in advance of the site visit. And if anybody feels that there's a site or location that's been missed out, they can raise that prior to the actual visit itself. Is the acquiring authority happy with that, to undertake that for me?
Yes, sir, there's a willingness to do that, and there's general support for the approach that you've suggested of having the site visit the day before the inquiry commences, because those who are most likely to attend on behalf of the acquiring authority will be there for the inquiry anyway.
Thank you. That's what I was thinking would be the case as well. Mr. Kelly.
I know the area well, having not just been at inquiries, but also having worked on site at Doonray for many years. I think the point you have raised about the locations being on bends and on roads is a particularly serious one. I don't think the layout of parts of the land there really lend themselves to, a mini busload of people being there. Having regard to safety issues, my clients and myself would have no objections whatsoever if, on the basis of an agreed itinerary, you undertook the site visit on an unaccompanied basis. I just think there are places along that road and on that route where it would be very dangerous to have a large group of people on the road edge. In many places, of course, there's no pavement there, safe refuge. So just to reinforce, on safety grounds, we'd have no objections to you having an unaccompanied site visit on an agreed itinerary.
Okay, I'll consider that matter and to see what's suitable. But noted about the health and safety, and that was one of the matters that I would expect the acquiring authority, if they're putting an itinerary together, to obviously highlight where there are potential sort of health and safety issues with regard to access the site. So that can be brought out in the itinerary itself. At the moment, I'm going to work on the basis of at least one accompanied site visit. It may not be to all the locations. So the accompanied part may actually be just to where there are significant matters of dispute between parties. So again, that can be kind of clarified. As we move forward, if sites are withdrawn, then it may not be necessary for me to spend time sort of at those. So we can refine that, I think, as the process moves forward, if everybody's happy with that approach in principle. I'm seeing nods all around. That's very helpful indeed. In terms of timescales for the submission of written submission statements of case, inquiry documents, precognitions, given the uncertainty now of when we will schedule sort of the inquiry and whether we're going for statements of case, that again will need to be sort of adjusted, just for the benefit of those who haven't participated before. For the inquiry session, you would require to produce a statement of case, which would provide the particulars of the case a party intends to put forward, set out a list of the documents which are to be referred to, and specify the witnesses who will give evidence and the scope of evidence they will cover and who will be leading the case and cross-examination. So the statements of case are obviously the initial and important in order to establish the scope of what we're going to do going forward. And we'd mentioned that earlier. If an inquiry session is held, each person giving evidence at the inquiry sessions will also need to lodge a precognition, which is a written statement of evidence, which should be no more than 2,000 words. Witnesses shouldn't attach any appendices to their precognitions or any documents which other parties have not seen. And any documents should be lodged as documents, as mentioned sort of earlier. The hearing is a different process. Those parties taking part in the hearing session must produce a hearing statement. I do not propose to impose a word limit on the hearing statements, but we encourage parties to be concise as they set out their positions. And the statement must provide full details of the case that they will put forward, and again list the documents that will be referred to and specify the witnesses that will speak to what subjects. Again, in terms of core documents list, that's something, given the number of parties, I would sort of ask the acquiring authority to coordinate, to pull that sort of draft list of documents so that we can get all that into the one location and with constant referencing to that. So I would ask parties to, together, when that stage comes, to produce a finalised and agreed core document lists. You can speak to our sort of case officers who can advise and assist sort of on that matter. But can I just check whether the acquiring authority would be happy to take the lead on putting together the list of core documents with the other parties?
Yes, so the acquiring authority would be prepared to do that.
That's very helpful. Thank you very much for that. That takes us on to item 11, which is under miscellaneous. And it's really just going through sort of process and procedure. So in terms of deposit of documents, all the relevant material connected with the case, including any environmental information, needs to be placed on deposit locally so that it can be referred to by members of the public. This will also include any further written submissions, hearing statements, inquiry statements, precognitions, and all documents. We can agree a location for the deposit of the documents and whether they are electronically held or hard copy. Again, I wonder whether the acquiring authority, I think you've already put things on deposit, whether that's something that you would be happy to facilitate, perhaps speaking with the council and to make sure that that's kept up to date. I don't know whether parties have tended to use electronic access in public locations rather than sort of paper copies. So I think, any comment on that at the moment from the council?
No, sorry, I don't have any knowledge of other documents apart from.
That's okay. Unfair question to you then at this time, so that's okay.
No, it makes sense to have something central.
Yes, yeah, it's just to have it in an accessible sort of location, whether it's a library, whether it's the council offices where they can be accessed by the public. I don't know whether the council normally use sort of electronic rather than paper versions of things.
Yeah, we would probably try to use electronic versions where possible. I'm not sure how well we're set up for sort of public viewing, but I can certainly look into that.
If you could sort of just link with the acquiring authority,
yeah,
that would be helpful, just in case you can help them facilitate. They may have sort of an option, but it's just to see whether you can help with that. Sorry, the acquiring authority.
So I think a suggestion of liaising with the council in order to come to an arrangement as between CMS and the council representatives would be the best way to move this forward, and be confident that they're going to be deposited in a place that's easily accessible and in a form that's easily accessible to all those who might have an interest.
Okay, that's very helpful indeed. Thank you for that. I would also indicate that parties should submit their documents and statements by email in a Word compatible format to the DPA. Again, our case officer can keep you advised of formatting and what to send in, but everything should be sent in electronically. The only exception to that is that I will need hard copies of any additional plans or maps or other similar material. What I would advise the acquiring authority is that I do have the existing drawings as were submitted to the ECU. So I have all of the current sort of drawings, but if there's anything additional to that, then I'd require additional sort of paper copies of that. Is everybody happy to do everything electronically? I'm assuming the answer is yes by the nods round. Any questions on any of that? No? Okay. So DPA website, the DPA website and contact details, all of the documentation produced for any of the oral sessions and all of the further written submissions will be published on the DPA website. So everybody will have access to all of the information that's coming in. If you're having trouble accessing that, again, the case officer, Morag Smith, would be able to assist with any issues that you're having. And Morag's details will be put on the note of the meeting, so you'll have her contact email address. Note of the meeting, as I mentioned, I'll prepare a note of the matters arising from the meeting, including details of the procedures that I will follow. Again, I will obviously be considering all the relevant dates as we've discussed and the following procedures, and will explain who's to submit what and when in terms of further written submissions. I will arrange to have all those. Sorry, I will start that again. I'll arrange to have the note of the meeting sent out to all the parties who are involved in the process, and to any others who have been attending virtually today but may have not participated. So the note will also include important references for parties, and it will record obviously the main procedural steps which we need to undertake. Obviously, we've agreed that the dates will be submitted to me in terms of looking at the rescheduling the date for the start of the inquiry, and also I will consider the proposal of, in terms of scope, the statements of case being submitted. So it may take me a day or two longer to get the note of the meeting out, but I would intend to get it out probably the beginning to the middle of next week, all going well with that. So the note of meeting will be the most important thing to take forward, and as I said, getting in your dates of availability again during October, which I'm thinking is what we're looking at now, would be would be very helpful. Item 12, any other relevant matters that haven't been raised today that anybody wishes to raise with me?
So there's one matter which has been raised, but you passed on before we were able to respond, and it was
Okay, my apologies.
No, it's just the format of virtual hearings that makes it difficult. It was specific in relation to your request that any legal representations be made well in advance. My instructor solicitor, Mr. Hutchison, was raising with me whether or not that related to the legal submissions that would be submitted as part of the first grouping of topics, or whether you're talking specifically about separate legal matters, such as any motions to postpone or adjourn, in respect of which you would want early advance notice.
My apologies for not giving the opportunity to come back. The latter of the 2 points you raised is what I was referring to, where there's the prior one. I haven't given enough consideration to that yet to know where we stand with that. But it was the latter of your points in terms of anything that was in the wings in terms of the whole process and procedure.
Thanks for the clarification, sir. Mr. Hutchison would like to raise a follow-up point based on your clarification.
Okay.
It was just hopefully for assistance in terms of the former of the two, the proposal that certain aspects of items 1, 2, 3, 4, and 8, the legal aspects of them are dealt with by written submission rather than hearing or inquiry. And I just thought it might help to present the acquiring authority's view of exactly which aspects of those items merit legal submission. I think Mr. Kelly had mentioned item 3, and it would be the inquiring authority's view that it's probably the second part of item 1. So the question of what options there are to acquiring title over the plot. So why, in the acquiring authority's view, the acquisition of lease agreements or servitude rights wouldn't be appropriate in this instance. That sort of second half of part 1 feels like a legal issue. And the second aspect of the agenda or the issues that appears to be a specific legal issue is the second part of item 3, which is the scope of the acquiring authority's powers under the Electricity Act and under the terms of its generation licence. But the legal point on the scope of the powers, so the sort of alternatives to the method of acquisition or the rights to be acquired and the scope of the powers. So the 2 points in particular that the acquiring authority views are kind of legal issues better suited to written submission than presentation of evidence.
Okay, so that's just so I've understood that. That's so item 1 and your second part, and item 3 in terms of the out with the scope of the licence. So that's the second part of that as well. Is that correct?
Exactly right, sir. The point from the sort of dash onwards on item 1 and the point from the dash onwards on item 3.
Right. Okay. I put those there, I think, because it was, from my sense, I was seeking clarity on that. So that's helpful that that's aligned with your own sort of thinking. Okay, that's helpful. Does anybody else have any sort of what Mr. Kelly already mentioned? I think 3. Any sort of comments without discussing, obviously, the merits of these things, but any internal comments in terms of what might be included in these submissions?
In terms of my client's interest, it would only be after the dash and number 3.
Okay.
I would be addressing. This submission might not be long, but I wonder, sir, in relation to legal submissions, if you would think about a 2-stage process of initial submission and then a rebuttal, so that you have the fullest possible thoughts on it. It may help you then to decide yourself the way forward. And I think now, with the inquiry date being pushed back, there should be no timescale difficulties in allowing for initial submission and then a rebuttal. Thank you.
Okay. Anyone else? Okay, that's helpful to get some clarity on those matters. I will now go away and put my mind to thinking about how we take this forward. As I said, if you could get those dates into me, that would be helpful. I've got no other matters. Does anybody else have any matters just in terms of what's been discussed today or procedure going forward? Happy we've covered everything that we need to do. Okay, that's great. Well, on that basis, it just remains for me to thank you all for your assistance this morning. It's been very helpful in terms of the clarity of the position that's come forward from everybody and sort of the positive approach to trying to move this forward. So that's much appreciated from my standpoint. So on that basis, I will again thank you all and now formally close the meeting. So have a good rest of the day. Thank you all.
Thank you. Thank you.
Thank you, sir.